It is so unusual and rare to have a vindictive prosecution or selective prosecution claim by the defense to get some traction. Now, let's take a dive into what has changed, because it seems like these kinds of defenses may start to get some traction now. And let's figure out, what does it take to make them work? So it didn't work for Hunter Biden, if you remember that. They tried to argue he was selectively prosecuted. In my opinion, he was. But here's the question now. Big case, a lot of publicity. It's been going on forever. Kilmar Abrego Garcia, he's the Maryland man who was mistakenly sent to that notorious prison in El Salvador in direct contravention of a court order in his own case, which had barred him from being sent there to El Salvador. And also in direct contravention, government disagrees, was in direct contravention, with a federal judge in D.C. who had ordered all those mass deportations to El Salvador stop, literally saying to the government, turn the planes around if necessary, which obviously they didn't do. And what about other enemies of Trump? Well, the James Comey situation, I recently wrote about the weaknesses of the Comey case in the Daily Beast and in an interview with the Daily Beast podcast. If you take a look at those pieces, you'll see how I expound on why Comey may also have a successful defense of selective or vindictive prosecution. But I note these are uphill battles for these kinds of claims. And well, let's see if maybe that hill just got a little less steep. Let's analyze it. But first, let me remind you to do a subscription button push and make us the biggest, we're already the best channel that does politics as well as legal analysis. So hit that button. Now, I'm going to start here with the opening of the opinion by the judge, because he points out the really important big macro picture here. This is Judge Waverly Crenshaw in Tennessee. That's part of the Sixth Circuit there. He's the district court trial judge. And he points out that, for context, a federal prosecutor isn't the representative of just an ordinary party, he says, but to the sovereignty whose obligation it is to govern impartially. And that's why the judge is starting out with this quote from a case from the Sixth Circuit, that it's the coercive power of the state that is important to guard against here, because the prosecutor's exercise of that very great power has got to be impartial. And, go back to the quote, the prosecutorial power may not be exercised vindictively, meaning that the prosecutor may not punish a defendant for exercising a protected statutory or constitutional right. So the judge does a great job here. We'll put up the link if you want to look at the full opinion, which is about 16 pages or so, but really breaks it down. And to summarize this analysis we need to be familiar with is there are basically two kinds of vindictive prosecution. And just generally, let me say, a selective prosecution goes more to the idea that you were picked to prosecute when other people who had done similar things maybe weren't prosecuted, for example. That was the Hunter Biden argument. Vindictive tends to be a little bit more of a reactive connotation, meaning there's something you, the defendant, did that the government's pissed off at you about. Like, let's say you refused to plead guilty, so they're ramping up the charges, things of that nature. And so that's the vindictiveness piece that we're addressing in the Garcia case. So the judge points out there are two kinds of vindictiveness. The first is actual vindictiveness. And he says, look, this could be based on some of these statements that Trump and other officials have made about Abrego from the time that he first filed his Maryland lawsuit challenging what had happened to him. Now, the vindictive part is always harder to make if it's actual, because a lot of times that ends up going to the question of what did the actual line prosecutors do or say that says we're going to get this guy for doing this. But here you get to see, and this is a clue as to what's changed in the landscape, that the main prosecutor overseeing the criminal division in Maryland and the acting U.S. Attorney McGuire there had told the public on television on the day of Abrego's arrest that the government only started investigating him after a judge in Maryland questioned the government's decision to deport Garcia. And that they said it had no right to deport him and accused the government of doing something wrong. That's when they start the criminal investigation. And that top prosecutor there also stated that Abrego was not returned for any other reason than to face justice. Then the court also points out that the Deputy Attorney General, Todd Blanche, Trump's former personal attorney, the number 2 at the department, said that the criminal case was brought to return Abrego to the United States, not because of a judge, but instead because an arrest warrant issued by a grand jury in the Middle District of Tennessee. That could be direct evidence of the vindictiveness, meaning they are trying to get back at him for having exercised some constitutional right, for example, filing a lawsuit challenging what happened to him. That would be the direct, actual vindictiveness. The judge also points out that there is an analysis called presumptive vindictiveness. And that's when there's indirect evidence to determine by the standard whether a reasonable person would think there existed a realistic likelihood of vindictiveness. There, the court looks at two factors: prosecutor's stake in preventing assertion of the protected right, and two, the reasonableness of the prosecutor's actions. Court here says, when you take a look at these things, both factors are present here. The government had a significant stake in retaliating against Abrego. Why? This has been like their bane of their existence and a poster child for the wrongful injustices that the Trump administration is doing. The illegal deportation, who cares? There's an order in his particular case saying don't send him there. We're going to send him there anyway. Who cares? There's no due process for any of the migrants who got sent there. We're going to send them anyway. Who cares that a judge said, turn the planes around, we're still going to do it anyway? Garcia's lawyers and him, by challenging this, shone light on this. He became the face and name associated with it, and it caused a huge problem for the United States, for the government, for DOJ, for Trump. They had to admit they were wrong. They had to contact the other country to try and bring him back. They had to figure out, how are we going to continue to try to deport him? By the way, I think all the continued efforts to deport him within the immigration context are also vindictive. But we're only talking about the criminal case that they managed to drum up from a years ago traffic stop in which nothing happened. Those are the things that indicate there's a dog in a fight, a big dog, for the Trump administration here. That's why they would want to retaliate. The judge also points out one of the standard clues in wrongdoing by the Trump administration, which is people are resigning. So the judge notes in a footnote that it might be that Deputy Attorney General Blanche's opinion distressed the former chief of the criminal division at the U.S. Attorney's Office in Tennessee, Ben Schrader, because Schrader resigned the day Abrego was indicted because of what some suggested were his concerns over the case being pursued for political reasons. Always a good clue in the Trump administration is, look how many people are resigning. It's not just the individual prosecutors, right? That's what the court's pointing out. You can look at the fact that the entire executive branch has a dog in this fight. They have a big stake because they've been embarrassed, they're pissed off, they have to continue to do this. It's become a turning point for them on whether many of their actions against migrants are legal or not legal. They're gummed up in the court system. That's their stake. They're pretty pissed off about what happened. And the judge then points out the next steps here, says, Abrego has carried his burden of demonstrating some evidence that the prosecution against him may be vindictive. And now that he's done that, the government bears the burden of rebutting the presumption with an objective, on-the-record explanation, such as government discovery of previously unknown evidence. Ain't going to happen here. It was all known. Or previous legal impossibility. There's no reason why they couldn't have brought this before. But the court says we need further discovery, and without that, the court can't move on. That's so important because most of these claims don't even get to that point. They just get dismissed out of hand. And the discovery is important in any case, not only because it's shining light for the parties litigating it. They need that information to go forward. But here, it also shines light for the rest of the country as well. So we'll keep an eye on this for you and talk to you soon.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.